Good afternoon to all. I, Professor Dinesh Kolte, coordinator of this one-week online workshop on Indian Penal Code, warmly welcome to today's resource person, Honorable Professor Dr. Nandini CP Madam, Associate Professor Damodaraya Sanjira, National University, Visakhapatnam. I welcome you, Madam.
Namaste, sir.
In this on this sixth day, I cordially welcome all the participants across India. I heartily welcome our beloved Principal Dr. Semrao sir. Today's resource person is going to enlighten us on the important topic, that is principles of joint liability, joint criminal liability. I hope definitely it will benefit us to understand this important topic. Once again, I welcome you all on the 6th day of sessions of this online workshops. Thank you, madam. Here, over to you.
Thank you, sir. I once again welcome our resource person for today, Dr. Nandini CP, ma'am. Ma'am, I'm very sorry about that. Dr. Nandini CP, ma'am, does not need any introduction, but still I would like to take this chance and say a few words. Dr. Nandini CP, ma'am, completed her BA and LLB from Mysore University by securing 3rd and 2nd rank respectively. Ma'am also finished her LLM in criminal law from Bangalore University in 1997. Ma'am earned her PhD from Osmania University, Hyderabad in 2014. Ma'am is currently working as an associate professor of law at DSNLU, Visakhapatnam. Ma'am is also a member of the Executive Council, DRC, and the PG Council. Ma'am also holds the post of convener at Legal Incubation Center at DSNLU, Visakhapatnam. Ma'am has also worked as a Dean of Examinations from 2016 to 2018. Ma'am was also the head of Disciplinary Committee from 2015 to 2018. She was also a member of Curriculum Review Committee and a member of Academic Council. Ma'am has been called as a resource person at various prestigious events. She has also authored countless articles and literary works which were published in many national level journals. Ma'am has also been a part of many workshops, training programs, orientation programs, etc. on international, national and university level. Ma'am, it's a delight to have you here with us today. Before I pass the charge of today's meeting to ma'am, I'd like to tell the attendees that if they have any questions at all, they can leave them in the chat box section of the Zoom meeting or in the live chat section of the YouTube stream. Their questions will be entertained by ma'am once ma'am is done with her address. So without any further ado, I now request Dr. Nandini CP ma'am to please take charge of today's meeting. Over to you, ma'am.
Thank you, Meher. I hope I'm right with your name.
Yes, ma'am. Yes, ma'am. Certainly.
Meher, if you don't mind, can I take the questions as in the chat box and reply instead of waiting in the last, if your organizers permit me? In case if the participants have any doubt and I feel that it is a relevant one, with the due permission, can I answer the questions in between, Meher?
Yes, no problem, ma'am.
Okay. Thank you so much. And I'm humbled with the introduction. I think that was little, that is so much, which as an academician, I'm glad to be here serving the academics. And I heartfelt thanks to Rao sir, who has been with us for more than 1.5 years. And he was a guide for us. And he was, as an elderly, he has given so many suggestions, which I have imbibed in my life. Thank you, Rao sir, for inviting me to your college of from Aurangabad. And I would also thank Professor Dinesh, who has been coordinating with me, and all the organizing committee, as well as the participants who are there. I hope we will do some learning from the expectations which we have. First, can I share this ones for all of you, so that it will be convenient for exactly how exactly we'll go about. Now, how have I planned my lecture? If you think about it, then I will always tell my dear friends, whenever you're talking about a crime, I have seen the topics which were given. What is the topic which I've given? Some are more specific topics, and yesterday you had something on essentials of criminal law. If you look at the essentials of criminal law, you all know that the elements that has to concur together in a criminal law is both the word actus reus and mens rea, which all of you have learned in yesterday's lecture. Now, should we go one step ahead and then learn what exactly is this actus reus and mens rea? Will I go back to the yesterday's class? No, I'll continue. I really did not have time to go here. I heard a couple of lectures because we had some other work. I could not really ping in into the YouTube or channel, but I still understand what the yesterday's resource person would have exactly represented subject as. If I'm talking about actus reus and mens rea, now the next topic which everybody have to understand is, what is the importance of joint criminal liability, my dear friends? What is this importance of joint criminal liability? Why there is a joint criminal liability? Can we make anybody liable in case if they have acted upon or participated? In case if they have not actively participated, can we make them liable? If they have neither acted, participated in the crime at the scene of the crime, or in case if they were not even present, can we make them liable? Or if they only planned, but they have basically not acted upon anything, can we make them liable? So there can be various types of questions which would come in. What are these various types of questions would have come before the court also? Will I only take up the Indian context of understanding what is this joint criminal liability? Or as a researcher, as an academician and a researcher, most of the time I would certainly take use of the literature which is there all around the world. What is this literature which is available, my dear friends? If you look at the literature, you read the best of the classic books which any criminal law teacher or a criminal law student or a lawyer or any participant who has been hearing me can take. If you really want to understand what exactly is a joint criminal liability which is happening all over the world, I would not stick to the jurisdiction of India, because I always read, and considering that the development of law which is happening all around, we should learn that how exactly the liability has been extended in other countries. Is it the same thing which is done from our Supreme Court? Is apex court or our high courts really taking the learnings which are happening, or is it enough with what we have within the parameters of our statute or the code which I'm talking about, the Indian Penal Code? If you look at the Indian Penal Code, friends, you know that there are few chapters which basically will tell you what exactly will make us learn or interpret what is the joint criminal liability aspect. There is no doubt all of us know. Can anybody answer me what exactly is this sections which you would certainly know that what are the sections which are basically there under the joint criminal liability in India? If you can put it in the chat box, I'll be little happy. It will become more interactive session than me going on and on and on. And then you will, at the end of the day, you will tell me what is exactly. Can anybody reply? Can I see the chat box here? Where is my chat box? Yes. Where is my chat? I'm not much used to Zoom, so I'm a little new to Zoom. Where is the chat box? Can anybody read what is there in the chat box? Yes, chat. Okay. There is no chat box. I saw some chat box. Yes.
Madam, there is a, if you see the below, you'll find a chat box.
Where, yeah.
Where share screen, near to the share screen, there is a chat box.
Okay. Thank you, sir. I'm so sorry that I did not know how exactly Zoom works much.
I hope
well versed with that technology.
You use the Webex.
Cisco, we use Cisco Webex. I'm still not able to. Yes, maybe is it in the comment section?
And madam, there is another option. If you go on book form, then this only the PPT will be seen.
Okay, we can't see the chat.
No. What happened? The PPT which you are presenting on this computer, this side is coming about. This insert design, this are coming. And if you click here near to the book form or near to that box. Here.
Exactly. Can you tell me where exactly is it going to be visible? Yes, I still can't see.
You'll find a sign of a cup there. Book near to the book. Last line.
I am trying to see all
yes. Yeah, near.
There?
Book. No comments. Here. Again in back.
Oh, the raised hand. Tamanna Shah has raised hands. If they raise hands, can they ask me questions, sir?
No, I think she.
Okay.
Madam, here there is a screen.
Yeah, I could see that till now. I don't know why.
No, I could see.
I could see it. Thank you so much. Yes, I have succeeded. Oh my God, I did not. It went off somewhere. Okay, I can see it. Now, somebody says that it is section 34, wonderful answer, section 145, okay, 49, 141, 134. Right, completely accepted the answers. Why do you think 34 and only 134 did you write? Why you did not write from 34 to 38? Most of us do that.
Yes.
Not only academicians do that. Most of academicians, all of us will teach section 34 and tell that this is joint liability. No, never do that. This is error once we learn it like that. We need to learn from section 34 till 38 thoroughly. And only then we will understand that what exactly is this joint criminal liability which is going to be impressed upon for the interpretation purpose which we can take. Now, why joint criminal liability is treated in a different way completely, my dear friends? Can anybody tell me, why do you think that joint criminal liability should be treated in a separate chapter, always in a criminal law book, or it is being read as a part of general explanation in India? Why section 34? Why section 141? Why section 149? If you look at, is it only that we are going to stop there? Or is there any other concept which talks about the parties to a crime and then the differentiation of liability which comes from their participation? Can anybody tell me what exactly is the differentiation which we can arrive at in the Indian Penal Code, telling that, ma'am, this is what we can learn. This is not only in 34, it is not within 149. Because if you look at 34, it talks about the meaning of common intention. If you look at section 149, you would look at the common object perspective of understanding. Are they same? Are they different? We'll come back to that explanation. But if you see what exactly is that, do you think that we should stop at 34 and 149 of understanding joint criminal liability and then forget about the rest of the things which are there, in spite of we don't highlight it as a common intention or a joint criminal liability? Is any other provisions of the penal code says that this is also part of understanding the joint criminal liability? Can anybody just give me the answers in the chat box, where I'll be little again happy with the answers which I've got? Where was my chat box? Again, it vanished somewhere. Yes. Can anybody tell me in the chat box what exactly is that which is being given here? Where is this? Yes. Where is this chat box? Again, it is creating problems. Okay. Sir, can you tell me what is there in the chat box? A couple of answers. Is there
Madam, see, if you go to the share screen.
Yes.
Here, it shows the color green color.
Yes.
Below, at the bottom of the, you'll find the share screen option. There is a green color shows, and there near to it, there is a chart.
I know, I saw that, but I clicked it also. I saw the answers also, but somehow I again have missed it.
See, I just actually.
I have again missed it. It's okay. Should I adjust it, or is it gone somewhere else?
No, madam. If you go on a share screen, we'll do one thing. First, adjust the PPT here. If you see then PPT, there is a book form.
Yeah, I could see that. Thank you so much.
Then
Yes.
if you click that
Somebody
next
answered me 120B.
yes.
Somebody answered me one. Is there any other answer which would exactly excite me to understand that people are getting to know that this is not the only joint liability? Conspiracy is a good answer. Conspiracy is an independent offense itself, and it's a good answer. Okay. If in case, without wasting our precious time, I would tell, is not section 107, liability of every person who committed. Okay. Is it not important for us to learn from section 107 to 120 to understand what exactly is the liability of various partners of a crime when you are committing it as jointly as an abettor or an aider, my dear friends? Don't you think that is relevant? You can reply to the chat box. I'll be super happy. Don't you think that is it relevant for us to understand section 107 to 120 of the Indian Penal Code, which is also talking about, if not directly telling you that I'm going to make you liable for a joint act, is your abatement and aiding and encouraging and counseling or commanding or a procuring concept, will it not come under joint criminal liability, my dear friends? Do you think that it should not be covered under joint criminality? What is exactly the concept which we have to understand? Can anybody tell me now? Yes. Yes or no? Don't you think 107 and 120 also should be part of this? Okay, yes, answered or not? I'll see in the chat box. It should. Thank you so much. Tina says that it should, ma'am. Yes, somebody says yes. Thank you so much. Now, giving you this overview of what you would look at in the Indian Penal Code, Nandini would not stop at the stage of Indian Penal Code. I will look at the what exactly is the interpretation or the evolution of this principle which is happening from time immemorial, and basically what we have taken from the other countries. Is India going beyond what we learned from English law, or we are going to stop at what we learned from Barendra Kumar Ghosh, Pandurang, and then Mehboob Shah, and then have we developed something till 2020 judgments? So recently I was referring to a 2020 judgment to understand, is there any better equipped principles which have come before the Supreme Court, which they are taking it? Because when we look at the other principles of criminal law, we have adopted to both the US court's decisions as well as the English court's decision, and most of the European court, the perspective which we have adopted as, and to a certain extent nowadays we are referring to Australian judgment, African judgment, and the Canadian judgment. But for this joint liability, are we stuck with section 34? And then are we struggling to say that is it good enough to cover the new concepts which have come up, or which is there in the international perspective, or is it going to be? If you look at the picture, I hope all of you are watching this picture on the screen. All of you are watching the picture on the screen, my dear friends. You just tell me. There are people who commit crimes individually. There are people who commit crimes with a group of people. There will be a gang leader who will sit from Dubai, like, and then tell hello, kill somebody as such. And the rest of the people who will be acting on their behalf. In case if you're talking about one puppet master, I hope all of you understand what is the meaning of a puppet master. There are various puppets. Then the puppets will act based on this master's order. The master never comes into the picture. He is nowhere in the picture, and he just sits somewhere in the corner. He is not going to participate actively in the commission of the crime. And he is the one exactly plans, and somebody executes the plan for him. Now, if you talk about it, friends, do you think that the puppet master, because he is not actively involved, can't we bring him under the law, under the purview of law, to make him liable, irrespective of where he is, what he is doing, etc.? So, for example, the pictures which has been shown says that there can be one master who is going to talk about, and once you tell master, there will be somebody acting under him. Now I come to the theoretical explanation of what exactly do we mean by that. Why the courts and the society get threatened by joint criminal liability, my dear friends? Look at the seriousness. If somebody is attacking me alone, it's easy for me. If it is, they don't carry any dangerous weapons, etc., then it's easier for me to attack them or defend myself, and then tell it, okay, I'm a little safer when one of them comes. Think, for example, there are two or more people coming and attacking. Is it not per se dangerous to the safety of the society and the human beings? It is considered per se to be dangerous. is the reason the legal, the parameter which we look at for joint liability should have a wider perspective, because a large number of people, my dear friends, large group of people, large doesn't mean what should be beyond hundreds and all. Large includes for me 2 or more people coming together for an attack on the person, where you're going to make a complicity, what we call. Nowadays, when you're looking and reading at the criminal law, the words used are not just common intention and common object. The common purpose, which earlier used to be called in the English language, that is what we amended the Indian Penal Code after certain amendments were made when it was in 34, that when Section 34 was there, my dear friends, they did not have something which was in furtherance of common intention in the beginning, but they later added these words in the amendment. The purpose of doing it was, the amendment was brought so that it could be on par with what was English law. Now, if I say English law, then we have to understand what's the common law development which has happened in the present generation. Now, what is that to the extent which we have gone, my dear friends? Look at this, what is being talking about. They use the word complicity. What is the meaning of this word complicity? There are wonderful research articles published in various peer-reviewed journals, which they write that is responsibility for helping. I think some people should be switching off your videos, because you are not in a sitting position. It would be more comfortable. Thank you so much. Then the complicity means a responsibility for helping. What are you helping? Everybody appreciates if you help for good reasons, but none of them, including law, will appreciate you, and they make you liable because that has extended to you committing an unlawful act or an illegal act, if not prima facie an unlawful act or an illegal act, or it at least through an illegal means you are doing it. Now, let me connect it to yesterday's sessions, what you had. Yesterday, you must have had a session on actus reus. In actus reus, you would tell that an act which is prohibited. That is what is the definition. That is an act which is prohibited. Now, if your act is prohibited, now I will ask this question later part of the discussion again. Now, is omission also part of joint criminal liability? You recollect and keep the answer. This question, you please write it down or note it down and then keep it. I'll ask you this question again in the last part of the discussion, that omission should also be brought part of joint criminal liability. And if is it only act? When we're talking about act, is it going to be only act, or we are also going to make it as an overt act, or only omission can also be brought under the joint criminal liability? This is a very, very important concept, because I'll tell you, my dear friends, unless and until you understand that actus reus doesn't mean only an overt act, would it include omissions? That is why I told you to read section 34, 35, 36, 37, 38. There we understand, when we read the principle of actus reus, which you must have done it yesterday, there is an inclusion of not only act, but also omissions, which makes an actus reus. If the same principle have to be extended to the joint criminal liability, then we are talking about, can you help somebody by doing an act, and can you help somebody by not doing an act? Can anybody answer this question? Can you help somebody by doing an act, and can you help somebody by not doing an act? Can you be imposed with criminal liability? In the chat box, can I get an answer? Thank you so much. Barendra Kumar Ghosh. Yes. Can you answer me this question, my dear friends, who are exactly hearing me? What was my question? I told that can there be a criminal liability for doing and not doing? Yes, common object and common intention, mentally and actus reus. It might be planned and spontaneous, and omission include will be liable. Okay. Shakti, thanks for the answer, but that would come little later, my dear friend. That would come little later. The purpose of me telling that would come little later is to tell you that I am still not come to that stage of asking that is it going to be planned, spontaneous, or whatever it is. It's always premeditated. I know that any crime, if it is premeditated, it's automatically going to be liable. That's a good answer, but I will take that answer little late. I'll certainly take that answer. Now, if you're talking about complicity, we know that we are going to help somebody for a criminal act, and for helping for a criminal act, I'm going to be legally responsible and answerable. That's one point which is very, very clear. Now, if I talk about who are these people who are helping me, who are these? There are various parties who will help me. Yes or no, my dear friends? It's not that I and my family only help me. There are so many people out of my family also helps me in committing a crime as such. So when you're talking about who is helping me, my dear friends, you should look at the stages of crime, at what stage they have helped you, and if you help, at what stage you can be made jointly liable. I'll ask you one simple question. Hope I'm understandable. Dinesh sir, if there is anything which is with little difficult or it's challenging, please let me know. If I have to go a little slow, let me know.
No, madam. Only thing is that
Ah,
this PPT should be enlarged because there is a button here.
okay.
If you see this, you'll find
Ah,
this book form, and there in this cup form, book form on the.
now,
Yes. Right. Thank you, madam.
thank you so much. But if you do this form, no, sir, I have difficulty in reading the chat box. That's why I thought I'll make
No.
it this small.
No, there is no chat box. That is different.
Okay. Thank you so much. Thank you for the help. Okay. Now, if you look at my dear friends, where was I now? Where did I exactly stop? With this, though I am little techno savvy, but still I'm feeling it. I should have practiced Zoom se kaisa karna kaam. Okay. Now let us look at this. If you're talking about the stages of crime, yesterday you must have learned this. That is forming an intention, then preparation, then comes your attempt, and then from your accomplished act. If you're talking about a intention or a recklessness or negligence or motive or ill will, my dear friends, can you make anybody liable prima facie for forming an intention? Can you make anybody liable for forming an intention? Just forming an intention, can we make anybody liable? Yes or no? Yes or no? We can make somebody liable for forming an intention. That's correct. But the thing is that in case if you want to impose a joint liability on somebody who is thinking, can you make them jointly liable if you have nothing to show to the court that they were also participating in the crime? This is a challenge before the court, my dear friends. What is this challenge? Think, for example, you are present in the scene of the crime. You are just present in the scene of the crime. There are people whom we call as passive spectators and active spectators. All of you must have heard about who are the spectators of a crime. हमारे देश में, when you look at people, if somebody is beating up somebody also, we are least bothered. We will not even ask क्यों मार रहे उसको, because if we go and stop them, they will beat us. So we look at our safety, and we usually do. But there are certain people who really helps them out. We leave at the exceptions. Maximum number of people we don't help them. Look at these person who are passive spectators. Now, are these passive spectators, don't you think by keeping, or are they present in a particular crime? That means they are watching a crime and they should be held liable. Don't you think that this is also part of joint liability? Or we should stop at some point and tell that we should not extend this liability unreasonably. Can anybody tell me what did I mean? Can anybody tell me what did I mean? We should not extend this liability more than requirement. The reason I told you is, my dear friends, when we are basically looking at intention as an ingredient, unless and until there is an overt act, or if there is one step beyond intention, in maximum number of criminal activities, we will not know basically the principal offender we have to make them liable. We don't even know that the principal offender can be held liable if there is only intention, unless and until there are certain specific crimes which has established through the ingredients that forming an intention is also a crime. Like, for example, dacoity. Coming together as dacoits, that is coming together, forming an intention of committing a dacoity, is itself a crime. Preparation is a crime. Attempt is a crime. And act serious is also crime. Act also. So there are certain offenses, like against offenses against state, what in English law they call it as treason. You are going to make them liable at all the 4 stages of crime. But that is not possible always in all kinds of crimes which have some specific ingredients to be made. So we have to understand, in order to make somebody jointly liable, should they be participes criminis? I hope all of you are well versed with this word. That are they part of participating in a crime? What you popularly called as accomplices, or even accomplice of this crime. Now, once you are an accomplice, either you do very little act or you do the maximum act of killing somebody, and somebody just bringing an RDX and giving to you. Will they both be equally liable in case if there is a bomb blast which happened in Lumbini Park? There were people who just gave the support by bringing the RDX and giving it to them. But there were certain people who executed this in the park which was overpopulated. That means large number of people being there and killing large number of people. Who should be liable? Now the question before the court of law is, should we make everybody equally liable? That means equal liability should be imposed, all should be given a death penalty, or should we classify their criminal activities into various categories? How do we make them accountable for their acts, my dear friends? This is a great challenge. When you go to practice also, it's not only for academic purpose. When you go to practice also, my dear friends, you will understand this derivative liability has really caused a chaos, not only for academicians, to convince my students or to the practitioners or the judges. Sometimes maybe even they would not exactly distinguish between where to stop the accountability and where to impose the liability. So when you're talking about this, based on this, that this classification or stages of crime, we are very clear that when it is at the preparations time, we all know that yes, there is a liability which can be imposed. But when it is a mere presence as a spectator, you may also have a mental element telling that, "अरे मारो, तुम मार रहे हो ना? अगर मुझे भी chance मिला तो मैं भी मारता उसको." My dear friends, kindly understand this. That means every human being has some criminality in them. And when you are going, somebody is beating up, if the man whom you are beating up is really a crooked fellow or a rowdy or whatever it is, who is a gunda in that area, if some hero keeps beating up, no, all the people talia marte, siti bajate, that means they are making it very clear that I am very happy that you are beating up, and if I get a chance, I will also beat up. Now, can I make a criminal accountability on mere my mental presence? I'm standing in one corner, I'm not going to do anything else, but exactly I'm going to tell him that I am very happy and I would really like to be part of this crime. Now the question is, are we going to make people liable? There is a wonderful law judgment in R versus Allen, which is exactly given in 1963. All England Reporter, my dear friends, kindly refer that in case if you want to do a further study after this, the minimum of discussion what we do, kindly go and read things which would make it clear of what exactly we are going to give an overview of joint criminal liability. Now, if you're talking about, there were soldiers who were raping in R versus Allen. The soldiers were raping, the group of soldiers were raping one woman in their actually barrack. And then a couple of, that means few of the soldiers entered that. They ought to enter it. That means it was not accidentally entering. They had to go to their barracks and they all went to their barracks. But I'll tell you, my dear friends, none of the soldiers who entered even tried to stop the rape, or they did not even comment on this. But they just stayed back there. They watched it. They were neither happy, they were neither unhappy, because their action did not show that they were happy or unhappy. Now, the question before the court of law, are these people basically acting together? That means by being in a place where their mere presence at the scene, is it going to be sufficient actus reus for a secondary liability? I know they are not principal offenders. I know that they are very, very clearly, the act of these people will not show that they are principal offenders. But are they going to be liable as secondary offenders? What are these secondary offenders, my dear friends? When you look at this joint criminal liability, you read any best of the research papers, Smith and Hogan. Now that Kenny's outlines of law has become a little old, I would read Oxford handbook on the handbook on criminal law. You read this, I'll tell you, there is so much of things which have developed further. Then if you look at the Oxford handbook on criminal law, if you look at Smith and Hogan, if you read these books, you can find all these commonalities in giving titles to this joint criminal liability. What other authors call it as complicity. Joint criminal enterprise is a new mantra of the world. Kindly understand, my dear friends. These days, we are what we call in India still now common intention, common object. Oh, sub, it has been merged into. They say that the earlier use of words of common purpose, what we have been learning in India till now, in the other countries, they have come to a title which has been, I don't think the title exactly enterprise is something which is a very, very good for a criminal liability, but still what we call as joint criminal enterprise or joint criminal liability, what you're talking about, is a new name given for common purpose. And the new subtitles which are given these days are parasitic accessorial liability, derivative liability, vicarious liability is very, very popular, and accomplice liability, which we are talking about. But when it comes to vicarious liability, my dear friends, can you make somebody vicariously liable for a criminal act prima facie? Or is there any requirement of special order being made in a given situation? Or do you think that there must be an authorization to commit a criminal act? Only based on that authorization that I'm going to make you liable? Is that the concept which we have to understand in vicarious liability of a criminal law? Or, my dear friends, do you think that vicarious liability can be ipso facto being held, that anybody who is an employer-employee relationship, master-servant relationship, it can be prima facie that master can be held liable for all acts? Or do you think that it should be specifically given to only in a given or a statutory liability which can be made through? What is meaning of statutory liability? Can any one of you write it down? What's the meaning of statutory liability? Criminal liability which has been specified in a statute. If it is a general code like Indian Penal Code, it is well and good. But this, anybody is answering this question? Thank you so much. And then if you're talking about this, what was exactly I talking? I was waiting for an answer. Okay. For example, if you're going to make as a special statutes, I'll tell you, my dear friends, there are so many special statutes which make vicarious liability ipso facto. From the beginning, the statute itself says that you are going to be vicarious liability. I hope all of you know that there is a new, instead of Food Adulteration Act, there is a new Food Standards and Substances Act. In that particular case, in the new statute which has come, not only in the old one also had this, there is vicarious liability already imposed. So you can blindly make anybody liable if you have a master-servant relationship. But that cannot happen in all the ingredients of other criminal laws unless and until there is a specific concept or given it in a statute as such. That's one concept which I would like to tell. Now, if you're talking about derivative liability, it refers to being held accountable for acts of another based upon assistance provided to that person. Anyone who intentionally participates in the crime as an aider, abater, co-conspirator can be held liable. Now, based on the derivative liability, it becomes important for us also to understand that when do we do all these things? If you remember what has been done in Mahabharata, if you watch, you know, Krishna does one small act. If Krishna was there, Lord Krishna, you would have been after the Indian Penal Code. He just takes one straw, slits it, and he has to indicate that you have to kill Jarasandha in this way. You have to slit that straw or a small stick, and he did not throw it in the same place. He threw it in the opposite directions. If you all remember, if you recollect all our Mahabharata epics also, I tell you, there is a lot of criminal law learning which happens. So when he says that, is Lord Krishna basically aiding Bhima how to kill Jarasandha? Is Lord Krishna also, when he says, that is Bhima, to how to exactly, where exactly you have to hit Duryodhana, he shows the high part of it and says that there is the weakness. Is he actually communicating, tell that how an act should be committed, my dear friends? Do you understand that what exactly Lord Krishna is doing in all these acts? If it is 21st century Krishna, we could easily make him liable for aiding and abating the commission of crime. But Krishna was Lord, so we can't make him liable. So there can be a liability which can be imposed. I hope all of you must have read about this preliminary crimes in the last class yesterday. Somebody is eating and enjoying my class. I'm so happy that you have switched on your video also and eating. That's good. And in chaos offenses, that is, if you're talking about in chaos offenses, my dear friends, these are the 3 classifications of in chaos offenses. What are those 3 classifications? Aiding, abating, inciting, counseling, procuring, etc. Then comes your conspiracy, then comes your attempt. If you read any criminal law book, what we otherwise call as preliminary crimes, it is very clearly classified that these are the in chaos offenses. Why should a joint liability class should have about the concept of in chaos offenses, my dear friends? Can you tell me why should a joint criminal liability class have all these things? Because sometimes we can make them independently liable in spite of the principal offender being acquitted. What's the meaning of that? What is the meaning of that? In spite of making the persons, if you are abating somebody, if you are aiding somebody, if you are inciting somebody, or counseling or procuring somebody, or making a command over the other to commit a crime, in spite of the act which you have abated, the act which you have counseled. मैं कहूंगी, or that Ankita Agarwal ko maar do. If somebody tells Ankita Agarwal ko maar do, if I tell it from Visakhapatnam, is Avinash Rawat, who is watching this, can you think that Avinash Rathod, if he commits it or not, can I be held liable for abatement, my dear friends? Independent. Is it an independent crime? If Avinash commits it only, I should be making him liable. That means I should be held liable. Or I can be made liable in spite of Avinash taking my abatement or not. Is both of us, are we acting together? Now I have exactly incited him, or I have actually asked him and also counseled him to go and kill somebody. I have actually hired him. Think, for example, hum supari leke marte logon ko. So if you are talking about that, is it that only when marne ke baad I will be liable for causing an incitement, or I can be liable in spite of Avinash not killing? So these are the questions which we have to understand. Will all these come as part of joint criminal liability, my dear friends? Yes. That is why we are stressing upon not just on section 32, 34, not just on section 141, but the ambit of joint criminal liability has really widened, including the ambit of making a corporation liable for criminal activities. My dear friends, corporate criminal liability from Sussex case till now. That means what you're talking about, Standard Chartered Bank, Iridium India case, if you look at, we are making corporations also jointly liable, not only with the living beings, that means what we're talking as human beings, even the corporate can be held liable because corporate is considered to have the brains with basically with the directors as such. Now, all of us know section 120A and 120B, if we talk about conspiracy is being punished, and section 511, if your attempt is going to be punished as such. So there can be joint liability at various stages of crime and various other classifications of crime as such. Now there can be certain liabilities in complicity. What is the certain liabilities in complicity? It can be an act or an omission. How can an act? Yes, all of us know that. अगर हम किसी को मारो मारो बोलेंगे और जाके वो मारेगा, then we all know that people who told maro maro can be liable. All of you know, in the earlier days, there were sati practices which happened in India. Many people used to go for the procession when the women have agreed to go for sati. And there are people who have set up fire for her so that she can jump into it also. Now, will you make everybody liable who are there, or people who have actively participated? For matter of law, everybody who is going to be encouraging the practice of sati can be liable. But practically, we don't do that. But I'm telling you how it can be practically possible to make them liable. If that is the case, by keeping quiet or by just telling Rama Rama Hari Hari, Rama Rama Hari Hari, that is also a kind of incitement to commit an illegal act if there is a sati going on. Now think, for example, read R versus Brainbridge or any of the judgments which you're talking about group liability. Now, if you're talking about a robbery of a bank robbery or a burglary, which I'm talking about, my dear friends, you all know that in a robbery or a burglary, There are not a single person who can be involved and commit a bank robbery. It's very quite difficult unless and until it's an internet crime which is happening in these days, where the hacker can sit and transfer the money from one account to hundreds of accounts, or from hundreds of accounts to one account. I'm not going to that extent of causing joint liability. We may come at one point of time, but as of now, we are not going to that. Now, for example, if you're talking about a bank robbery which has happened, my dear friends, look at the parties to this bank robbery. Who all can be a parties to the crime? Then I will tell you. Few people we will create it on our own. We will tell that Mihir is one of them. Okay, Mihir is one of them. Ankita is another one. Akash is another one. Or Baren is another one. Think four of them. Baren is giving a gas cutter. What is this gas cutter or a laser cutter cutting weapon? That is a machine which would easily cut into the wall of it. But if Brain has to do that, he has to buy it from somewhere. And he buys it from X company. X company, can it be made liable? We'll ask that question a little later. That's a recent development of law. We'll take it into consideration later. But as of now, can we make the person who buys the cutting machine, if he is buying the laser cutting machine, knowing that there will be some illegal activity, can we make him liable? Or are we going to tell that only he specifically knows that this is going to be used for bank robbery, only then we can be making liable? Please ask this question mark. Keep your questions ready for that. We can make him liable or not. That is, two contexts are there. Once he buys it, he knows that I'm going to buy a cutting machine, but he knows that there are a group of people who are wanting it from me. But maybe they're using it for illegal activities or not, he doesn't know, but he gives it. He comes, brings it, buys it, and gives it to them. Now he knows that a couple of them are little crooked in that, then they do commit illegal activities. That is another additional point which I would like to tell you. And the next one is the one who is driving them to the bank to commit this robbery, driving them with his car to commit the robbery. The one who is exactly standing guard to see to it that nobody is watching. Two people who enter it, and then another van waiting to take the booty as well as take these people to another place. Are all of them playing a joint liability in this act of what you call as bank robbery? Now, in the process of killing, all of them very clear, telling that हम लोग सिर्फ bank robbery करेंगे, किसी को नहीं मारेंगे. But one of them carried a gun, and it was known to all the participants of the crime. All of them knew that one of them is carrying a gun, and he told it very clearly. I will use it only when there is a threat to my life or our life, and he takes it. All of you know that one is carrying a gun. Now, because now there is a threat to his life and his accomplices, he shoots and kills one. Now, my dear friends, would you think that we can make all the 5 to 6 people jointly liable for the criminal activities from the case of buying it till the end of carrying away the booty? That is one question. Now, while carrying away booty, we know that all of them are doing an illegal act, so they can be participants, criminals, accomplices. Now, I will go one step ahead. There is one policeman who is watching all these things. When the booty is carried forward, he was just watches. He doesn't stop. He will just go. Before that, I will give you one more example. There is a bank clerk who has given, instead of using a laser cutting machine, there is a bank clerk who is out of in Switzerland going for his holiday. But before going to Switzerland, he gives the vault secret numbers and then goes to Switzerland. He is no more planning. He is no more actively participating. He just gives the code of the vault and goes. He is very far from the scene of the crime. Now, if you look at the context of illustration which I have given, my dear friends, each one of them have played their vital role in completion of a crime. At the time of forming an intention, they have come together. At the time of preparation, they have come together. At the time of attempting, they have come together. And they have completed the act, so it doesn't stop at attempt. It is a complete act. That means there is an act of serious. Now, at all stages, you can see that there were joint criminal liability. Will everybody be held liable for the killing also is a major question. Or can we make only that person who shot should be made liable criminally? That is the crux of the argument in the court of law. Whenever you look, whatever judgment, if you talk. Now I was reading the recent judgment, Rohtas versus and another versus state, 2020 Supreme Court judgment. I was reading Karnail Singh, the judgment which has been really discussed in all the recent judgments. Look at what you call Balwant Singh. Look at what is calling as Bandura. What is what is that? Who is that Shah? Mahbub Shah. Look at Barendra Kumar Ghosh. These judgments, which have been decided from 1940s till now, my dear friends, all of them are referred in the 2020 judgment of the Supreme Court also. Anywhere you look at what they talk about. Now, will the policeman, is he doing an act or is he omitting to do an act? Can anybody tell me, is he doing an act or is omitting to do an act? If everybody have written in the chat box, can anybody tell me what exactly is the answer? So, looking at this, we can understand that actus reus and mens rea are coming together. Now, association is a threat, I told you. Can anybody tell me what is a picture which both all of you are watching? This is the two pictures which I've given. Now, if you're talking about the pictures, there are people whom you talk about what I would like to call it as de minimis contribution. How many of you have heard about, de minimis contribution? In the Holocaust, which has happened in Germany, my dear friends, if you read any of the good books, you would like to know what exactly is that. Now, in the Holocaust, what had happened was a company was exactly supplying Xylon B. This is the gas which was used for that is what you want to call it is with your name. You want to call it as a genocide. You want to call it as murder. You want to call it as extermination. What is that? Zyklon B was the one which was exactly used by the Germans to actually use in gas chambers to kill large number of people. Now, the company which was supplying knows that this Zyklon is used for killing of people. Now, if they supply this, now do you think that they should be brought under the criminal liability? In the same way, if you're talking about acid attacks, and one of the pictures which I showed was Lakshmi, who was attacked with the acid attack. Now, if acid sale is not there in a shop, do you think that there could have been an acid attack? So can you make the shopkeeper who is selling that jointly liable under the law, telling that because he sold this acid, that is why there was an acid attack, so he must be held liable. Do we make people liable to that extent? Should we extend the liability of joint criminal liability to a large way, my dear friends? That is a challenge which has happened time and again before the court of law. So don't think that we can make anybody and everybody liable, even if it is de minimis in nature. There is a requirement that he must have had at least knowledge. That is an essential ingredients to make you liable. Or if not knowledge of that specific crime being committed or a specific act, prohibited act being committed, my dear friends, you must have knowledge of foreseeing what may happen. Kindly understand. In a causation, if you're talking about criminal liability, you have to know about the causation. Step by step, look at what happened in Barendra Kumar Ghosh, what happened in Pandurang. You are looking at what was going on. There are a group of people who are involved in the commission of the crime. And at the end of the day, one of them will plead before the court of law telling, I know, I was holding the gun, but I did not intend to kill anybody. So I should not be held liable for killing. This is what they will plead before the court of law. As a defense counsel, it is your duty to see to it that your client gets this protection, telling that he did have similar intention, but he did not have a common intention. So that is the distinction which you have to make in the court of law, telling that what is a similar intention? रॉबरी करने का इंटेंशन था लेकिन किसी को मारने का इंटेंशन नहीं था. So this is how we have to prove it in the court of law to bring your client out of the purview or clutches of the law. So when you are doing though, my dear children, if you don't exactly understand to what extent the joint criminal liability has to go, then I don't think we will be successful in claiming a good defense, or neither the prosecution will be good enough to understand that what exactly they have to prove before the court of law. So this is one wicked association prima facie. If I am with bad people, don't think that I am going to be bad. If you look at Sutherland, he says this differential association theory, he clearly says that a thief can still be good, even if it is with a group of thieves which he is sitting as such. So there are possibilities that we can be surrounded by bad people, but we don't participate with them, and then we cannot be held liable only because I am with the wicked association, unless and until, my dear friends, I do some wicked act, including an intention which is prohibited by statutes. The Indian Army Act says that if you tell anybody, and the rules also says that if there is vicarious liability, it's a vicarious liability. You don't have a choice. You are master servant, then you are going to be held liable. Now look at the olden day and now what is there happening in section 107 to 120. I'm going to connect it to various sections. I'm not going to teach section wise, though my PPT show that how section wise also I have prepared for the lecture as such. Now, if you are going to make liability, impose a liability, the court has to impose a liability, my dear friends. Do you think that you can make an accessory liable only when the principal offender is liable? Or if the principal offender stands acquitted, do you think an accessory has a right to get an acquittal? Can anybody answer this question in the chat? Can anybody answer this question in the chat? Yes, feedback link, please. Oh, somebody is already asking for a feedback link. Helping and omitting, feeling like seating in the class. Very good. Okay, thanks, madam. Okay, okay. You just answer my questions. Then we will have the feedback. There is a lot of time to learn. We'll just learn first. We'll learn. All can be held liable. Okay, Ramesh. Thank you so much. All says that. What was my question? What was my question? Basically, my dear children, if you are understanding it, and everybody help it, all are going to be liable. There are people who are answering that all are going to be liable. Now, if you're talking about that, my dear friends, and then we are going to talk. Oh, what is that? Where is my share? Okay. I did something wrong. Right? Escape karenge isko. Oh my God. No. Yes, I was here. Yes, I was here. Now look at this. Earlier days, when the criminal law was at a developing stage in 17th century and 18th century, my dear friends, it was very, very clear that if the principal offender is going to be acquitted, all the accessories also would get acquitted. Because without the principal offender, you could never make anybody liable. Because there is a joint liability. If the principal offender himself gets an acquittal, accessories would always take the benefit that it was there. It was not only like that, it was also if he gets a benefit of clergy, if he is successful in his defense, it would automatically affect. And if it is husband and wife, there was always no criminal liability between husband and wife. So based on all that, once the principal offender gets acquitted, it was automatically telling that the offense, that is the accessory, also would be liable. But that is, he would be acquitted. But there was a statute which was brought in the year 1861 in English law. And I think because of that statute, before that, the Indian courts, that is Indian Penal Code, when it was made, they were, Macaulay was very, very clear that the English principles should have been already inserted in the code. So they inserted this in the code. An abater can be held liable irrespective of the principal offender being held liable or not. So look at section 107 and 108, which talks about what is abatement and who is an abater. So a person who instigate counsels is an abater. Now, should he be liable only with the principal offender? It is very, very clearly said. He can be. Look at section 111, 112, 113, 114, and 115. 115 ko mat dekho, lekin 101, 111 to 114 ko dekho. It very clearly says that in spite of the principal, they don't specifically say that it's impliedly there, that you can be held liable for acts, basically to tell you that irrespective of the principal offender. I am not worried about principal offender at all in aiders and abaters chapter of abatement chapter in India. Once it is satisfactorily proved to the court of law that you are an aider or an abater, you are going to be held liable in spite of the acquittal, or if the case is dismissed or anything. But if your case stands, the prosecution is successful in proving your act, then I think there is very, very clear liability which is imposed in abatement chapter in India. Abatement can happen by instigation, abatement can happen by an act, and abatement can happen by incitement, and abatement can happen by a conspiracy. So there were specific provisions from section 107 to 120, which clearly says that what kind of, they say that you can be equally on par, the liability can be on par with the principal offenders, but only at some point of them that they say that it can be 1/2 of the punishment, 1/4 of the punishment as such. Why is this law, which has been extensively used, my dear friends? That is what I would like to tell. Look at this, what I have told. I already told you the bank robbery wala. Now I will talk about the classification of parties to a crime. I have given you basically a background of the case, or a background of an illustration. Now I will tell you who are the parties whom I am talking about to make the liability. First, kindly remember, principal offender, what we call as principal. No, not our principal, sir, but it is principal offender. Principal in first degree. Principal offender, sorry, I wrote the spelling wrong. Extremely wrong. One spelling is correct, one spelling is wrong. Principal offender of second degree. In that comes aiders and offenders, my dear children. They come as aiders and abettors. Then comes accessories before the fact and accessories after the fact. You know what is the meaning of all the classification of parties to a crime? Go back, read Kenny's Outlines of Law. Go back, read Smith and Hogan, or any even Katie Gower book will give you the parties to the crime. Excuse me. So kindly go and read the parties to a crime. First degree offenders are ones who have actively participated in the crime. So they are going to be liable. Aiders and abettors may not have been present in the scene of the crime, but they can be at the background or they can be later. There can be aiders and abettors before the commission of the crime, after the commission of the crime. This is what was a principle which has been established. Now, if it is accessories before the fact, that is what I have asked you. If you know that your friend has to be killed, in case if you want to kill somebody, think for example, you want to kill me because I'm eating the brains now. Now you take a small bottle of poison and then you mix it up with the coffee which I am going to have at 5:30. Now you know that this lady is somehow going to drink the coffee at 5:30 after the session. If you want, I'll go on till whatever time you allow me. So in case if that is there, then what happens is that till 5:30, you have an opportunity to come back of your act, yes or no? So if somebody has given you the poison or yourself has bought it, if you yourself brought this poison from a shop, you have a choice to either place it or not place it. That means you can add to my coffee or you can actually skip from adding it to my coffee. That means if you have a choice to do it. Now, if you come and mix it up, that means you have already completed your crime, yes or no? You have completed you will become the principal offender or secondary liability should be imposed. But before I drink the coffee, you think that अरे 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 क्यों मारना इसको यार, छोड़ देते हैं, ऐसे भी कुछ तो पड़ा रही है, छोड़ देते हैं इसको, नहीं मारेंगे. So what you will do is you will go and spill the coffee somewhere else. Did you act? Did you prepare? Did you attempt? You had a preparation, but you did not attempt. Are you going to be accessory before the fact? If you have helped somebody in bringing the poison, are you going to be accessory before the fact? If you are giving it to somebody, like you wanted to actually implement the poison on me, then if you are going to do that, my dear friends, are you going to be a principal offender of first degree? Yes, you will be the first degree, but unless you act, accessories liability will not even come to the picture. So that is the question which you have. And that is the reason when you're talking about, my dear friends, the new theories which have come up nowadays, there is something which is really extraordinary research going on all around the world about the joint criminal liability. So when I was reading it again, so I found that there are two concepts which are being brought up. That is objective theory and subjective theory. Parties who play a part fully or partially, they are joint perpetrators. No doubt they'll be liable. You are an aider, you are an abettor, that means whatever you could be ho jaye. If you are a party who have either completely participated or partially participated, that means partially means if you look at the sleeper cell, what is that holiday ka movie aaya tha? All sleeper cells will place their backs in each of the bag and then go out. If you're thinking so, my dear friends, if that sleeper cells have acted independently, they have partially acted upon for the whole crime which has happened at the same time the bomb blast had to happen. But each one of them are conspirators. No, they're not. They know who is telling them and they have to do it. That's all. None of them know that who is the other one acting with them. So you will have a chance to say that I have acted with consensus. If it is a conspiracy, you have to prove that there was an agreement. But here, there was no agreement together by all these sleeper cell. But there was an independent agreement with each of the sleeper cell, which would tell that, अरे तुम रेलवे स्टेशन में रखो, मैं बस स्टैंड में रखूंगा, मैं मॉल में रखूंगा. I hope all of you remember Holiday movie. This is what was Akshay Kumar was told to go around, and then he finds it out at the end, and then exactly he finds out who are going to be liable. If you're talking liable, each one of them are independently liable or are collectively liable for the act. So these are the questions which come before the court of law. So either they are fully participating or partially participating. Partial includes aiding, abetting, counseling, procuring, my dear friends. And then subjective theory. Parties as principals or accessories on the basis of their will and motive. That means in objective theory, you can see what has happened because there is an overact. But in a subjective theory, there is no overact. It depends on their mind. That is how you can it. Justice Coke told long back that no man can read, no devil cannot read a man's mind. Then how will a man read a man's mind? So I don't know what is your ill will or motive as such. But I will tell you, in case if you know, my dear friends, that I am of a gang of robbers, I am a gang who is exactly a group of dacoits. Pulan Devi gang, Nandini is also in the Pulan Devi's gang. And then if you're doing it, and will I tell that later on, I was not knowing that Pulan Devi is going to kill me. You can't take this defense as such because you know when Pulan Devi is there, there will be a killing, there will be robbery, there will be dacoity, there will be whatever possible offenses are there in a dacoit group can happen. So when you talk about that, you know that even though you plead that you are going to be ignorant that she would not have killed a large number of people, but once I am into the gang, I told that. And later on, if you say that you are an aider and abetter, then you can't tell that I was under duress, so I should not be held liable. You can be held liable unless and until you extend the defense of duress to such an extent that you did not have any options. So that is completely a different topic, but I just gave an example to understand how are you aiding and abetting people as such. In between all these hassles which we have in understanding the joint liability, my dear friends, there is something what we call as people using innocent agents. What is this innocent agent concept? What is this innocent agent concept, my dear friends? Can anybody tell me what exactly is this innocent agent concept? Somebody come out and tell me. I think I'll ask Mihir also to answer me this question. I'll be very happy, even if Mihir, are you a student or a faculty, Mihir?
Ma'am, I'm just a student, ma'am.
So can you just give me a idea of what I'm asking? Who is this innocent agent here? I would like somebody to talk to me when I'm taking a class.
Ma'am, maybe, I'm not really sure, but maybe the person who is not really aware of the full consequences of what he's about to do.
Yes, thank you so much.
I think that would be my best guess.
Thank you so much. Now, if you know that the other person whom you are jointly going to commit an act is a person who understands, so he can form an intention, he can form a reckless idea, he can form a negligence, he can form whatever mental element you want, he can form. But if he's an innocent agent, what is the meaning of innocent agent? Think, for example, the physician want to kill me. He will not tell anything. He will take one injection and tell to his nurse, इसको इसमें डाल दो, IVF में डाल दो इसको. So once that IVF में डाल दिया, Nandini चली जाएगी. The reason I'm telling you is that is nurse going to be a party to a crime, or she's an innocent agent? The act is not committed by the doctor. Please kindly understand. The act was nowhere directly committed. Is it important that the principal offender should commit the act directly to make him liable with this nurse? And the nurse be liable, or she'll be an innocent agent? Mayor, will she be an innocent agent, or she'll be liable for she'll be a party to a crime?
Ma'am, I think she'll be an innocent agent because she did not knew.
She did not even have knowledge. Now all of you understand, in order to make you liable for a criminal act of joint criminal liability, there should be minimum of mental element, basically say that yes, there is a necessity of basically something which must be there in my mind to tell that there is an active requirement of at least my mental element to be part of the crime. In the same way, if I don't know, I really don't know who all these people are, but if I take Rajendra Prasad sir, somebody is there who is called Raja. I can see their name in the box, so I can tell. If Mr. Rajendra is actually in love with some girl, and he wanted to actually pacify her and stalking her, but she doesn't really take it into consideration. At on one day, he was so frustrated with that. He told that एक गुलदस्ता में मैं उसको वो क्या क्या डर लगा देंगे, कुछ तो स्प्रे करके उसको unconscious बना के हम लेके जाएंगे. If Mr. Rajendra thinks that he can do it, what he does it, he gives a beautiful guldasta of, oh my God, beautiful guldasta of this rose bouquet, and send it to a 6-year-old child, a 7-year-old child, and tell that, oh, जाके वो लड़की को दे दो. वो लड़की करेगी, अब she'll get grievously hurt, because after that she will not, 20-25 days she will not get up. Child is again an innocent agent, my dear friends. An insane person who doesn't understand is also innocent. I'm giving you examples. It is not only that, your aiders and assessors can be even animals. There are people who train their monkeys. There are people who train their dogs. There are people who train their animals to act upon as an aiding category for you to be making joint liability as such. Think, for example, if you want to make an animal, if you want to make a child, you want to make an insane person liable, I don't think you can really make any one of them. But you can make the principal offender, in spite of he has actively participated in the crime or not, but his act has led to these acts, and I think that's more than enough. But there cannot be a joint liability when you are using an innocent agent, because innocence show that they did not have a mental element. But in one of the landmark judgments, I think it is Chanubai Mangala, some case where there was an illicit relationship, and that fellow actually had made the lady pregnant, and she was forcing that he should be marrying them, and he understood that abhi iska zyada ho gaya, wo abhi zinda nahi rehna chahiye. You know what he did? He actually poured pesticide into the woman's stomach, and that is, she was trying to pour it, and one of his aide helped him in holding the girl as such, holding the lady so that she opens her mouth, and he pours it into and the lady lies unconscious, and then they both run away. Both of them are principal offenders. The meaning is that one must have poured, but one of must have held. In the same way, when somebody is stabbing, you're holding somebody's hand. You both have acted equally, and for you to be held liable for murder. So these are the challenges which come before the court of law. So now let us go and then talk about what is this accessories at the fact, which is very, very interpretations which have been given by the court of law. Accessories before the fact are aiders, abettors, inciters, or procurers. But at the end of the day, it is not only accessories before the fact which matter, accessory after the fact which matter, but accessories at the fact also are matter. But these accessories at the fact which I am talking or I am interpreting, my dear friends, are those what we call as principal offenders of second degree. That means they have not played as much as the role as the principal offenders of first degree, but their role cannot be really very lesser in nature. They can be made equally liable. The liability degree may change to a certain extent. Maybe usko 10 saal denge to isko to 7 saal to dena padega. So if that is the highest punishment, then you may give them 5 years or 3 years. But their role has been very, very important in the commission of the crime. So my dear friends, kindly understand, when you are going to practice, you should be capable of distinguishing these the criminal participation into various categories to tell that I should make them jointly or severally liable. Now I asked you, jointly or severally liable. If there is a several liability, then why, ma'am, why should we study joint liability? Because several liability can be imposed even without the use of section 34(149), because all the law relating to abatement, and if in case it is a conspiracy also, I know there are cases where only one single conspirator was held liable. The reason is that not that there was no other conspirators, but the other conspirators must have escaped liability, or they must not have been booked. They must have not been charged, or they were not available to the books of the law. But there was one who was very, very clear telling that he must have acted with some, at least more than one, to make him liable. So this way, we can say that and classify it as a principle of various categories, my dear friends. And all of us know if accessories before the fact is equally liable, many a point of time they're equally liable with the principal offender. But the same law is not done for accessories after the fact. All of you must have read accessories after the fact. They are what we call as harboring in India. We call it in the name of harboring in India, who help people after the commission of the crime, maybe to shelter the persons who have committed a crime, giving them food and clothing. If you remember Nalini versus State, how many of you must have read all Nalini versus, is it CBI? Yeah, I think it must be CBI. If I remember the citation rightly, Rajiv Gandhi assassination case mein. After the commission of the crime, my dear friends, there were more than 20 people who have helped this Shivarasan and others to stay back in different premises in Bangalore. They have provided them food, they have provided them money, they have provided tickets to them to travel to other places so that they can shelter themselves. These are the people. And in Manu Sharma's case, what you call as Jessica Lal murders case, you must have seen their friends, their uncles who are politicians have been helping them to escape the liability. We all know that we can make them liable for running away from law. And these are the people who can be held liable. Accessories after the fact. That means they did not play any role in the planning or commission of the act, but after the act has been committed, even they can be held liable because they have helped the person who has committed a crime. So this is what I would like to classify based on that your liability can extend to various categories or classification of criminal activities which you do. Now, if you go by the type of the crime, my dear children, then the type of the crime also differs. I have answered you. This is a Maxwell versus DPP Northern Ireland case of 1979, where you are helping out a person who is an ultra volunteer force. That means you are a terrorist group, you are a Naxalite group, and you know that you are a part of them and you are helping them. You, in the earlier instances, you have actually dropped them to a place and come back. First time when you dropped, you were innocent. Second time you dropped, you know that there is some crime they are committing. Third time also you keep dropping them. And at the end of the day, you say that I have not perpetrated any violence. He says that I have not perpetrated. But by dropping them to a place where a crime has been committed, has he not endangered the society collectively, my dear friends? So in court, Maxwell versus DPP, the court held that when you know that there is an obvious possibility that you understand that there is a commission of crime, my dear friends, it obviously leads me to make you liable as such. So the knowledge that they're going to commit the crime and the foreseeability theory, which we call that, can you foresee nowadays when it comes to joint criminal enterprise, which I've told you, the word which in use, my dear friends, have been classified into two things. What is that? Exculpatory and inculpatory. What is that which is talking about exculpatory? By telling that I have not acted, I have done this, but I have not acted in the commission of the crime, you can tell that my liability should go till here only. After this, I should not be liable. Then you're telling that you are exculpating yours from the liability of one part. Inculpatory is that the theory has gone to that extent, the subjective theory which I'm talking about, my dear friend, it has gone to that extent where they say that in case if you could foresee the act of killing, like what happened in Brenda Kumar, what he could do when the postmaster, they wanted to attack the postmaster. In the process of attacking the postmaster, they killed him and then they tried to take the money, but they could not succeed. And one of them shot and one of them went running. The person who shot was never brought into court of law, books of law. But when it comes to person who was holding the gun and waiting, guarding as such, was held liable because he tried to run away, but later he was caught. Now he says that, why should I be liable? I have not killed the person. But don't you think there was a foreseeability which could you see that when you're carrying guns and when you're going to commit a robbery, don't you think that they should have understood or they should have a minimum foreseeability, that is foreseeing that what might happen, my dear friends? So based on this, if you can take, my dear friends, you can be held liable for a joint liability. So extend liability, I've talked about this principles which I've been talking about, JCE, that is joint criminal liability. You read thoroughly now the new concepts of joint criminal liability, enterprise, what you call, or I would call it as a joint criminal liability. Things have exceedingly gone further. Gangno case is one of the recent case, my dear children. Not recent 2000 wala case hai, for us in law 2000 वाला case क्या हम 1880 का case पढ़ के recently बताते हैं, लेकिन if you talk about that in Nangno you see that two people who were exactly opposite enmity जो है वो दोनों actually were shooting at each other. You know, when they were shooting at each other, in between there was one lady who was walking in the place where they were using it for shooting. One was running away, the other was running behind them. They had some enmity that there was going on. The innocent lady was shot by one of them, and they say that I did not intend to kill her. Now, can you take the defense that I did not intend to kill her? Yes, I know. You are in a shooting spear, both of them independently. They were not having a common object. They did not have a common intention, but they were in shooting spear. And this innocent lady is killed there. Now they say that I should not be liable because I did not intend to kill X, but I actually was either defending myself or attacking the other so that he doesn't kill me. So in that process, the concept which has been discussed in Gnano is that of parasital accessorial liability. Parasitic accessorial liability, which says that you should extend this. This is actually a sea change in the interpretation of law, which says that you should be extending the liability to these people because by acting against each other, they are also jointly acting, but they're severally acting. Independently, they can be liable, but jointly also they can be liable. But when it was challenged, the law, the dude, that is the judges have clearly explained to what extent you should be making them liable. So this is what I talk about, where you can embark upon it. Now I will talk about a little about section 34 to 38. All of us in the process of explaining all this, I have done with the Brenda Kumar Ghosh case, and then I have talked about Chimna Bhai Jagan Bhai Patel's case, where I have explained that case to you. I have explained Mehboob Shah versus the Emperor, where you find that the court has wonderfully distinguished between same or similar intention and in furtherance of common intention. Why are Indian courts so fancied about in furtherance of common intention? If there was no common intention, which all of them had to do it, my dear friends, you can't make them liable. And that is what has happened in what I told in the 2020 judgment, where the evidence was not proved good enough by the prosecution to tell us his act also has contributed to the death. So the court held that even though the act was in furtherance, what is it in furtherance? Agar hum lathi lenge, ek axe lega, एक gun lega. If you think that you'll take people with different arms and ammunitions if they go, the one who, people like me who can hurt people with their tongue, but they can't kill somebody with a gun, what they will do is they will take a stick. Agar chance mila to main bhi ek do maar do. There is very minuscule liability which I can also be held liable for hurt. But for me, I know that my independent act would not have killed them. What's the meaning of my independent act? So when you are bringing furtherance of common intention, many a times there will be a challenge that is your act independently enough to kill the person? Yes or no should be the answer. The prosecution has to prove not only one act, it to prove against all of them to make you liable. So 34, it is 2 or more. If it is 149, it's 5 or more. And there are cases, my dear friends, where 149 was taken, the charge sheet was filed under 149, and there is enough evidence to say that there was an unlawful assembly or there was a rioting. But even all the ingredients were there, but at the end of the day, you say that among all the 7, 5 got acquitted, 1 died, so it got abated. The case, the accused Dickies, now his case against him stands abated, ABATE abated. So the rest of them only 2 will be remaining. Now, can you make these 2 liable under 149 when you have acquitted all others? The question comes like that in the court of law. When you go to practice, this is what they will tell that you charge sheeted 7 of them. In that 3 of them got acquitted. 2 of them, 1 of them died. One of them was not proved enough. So there is acquittal of that fellow. And then there is 2 people who you can make them liable. Now those 2 people, will they keep quiet? Is a defense counsel like you, if you're pleading, will you keep quiet telling that okay, theek hai, 2 bache hai, lekin 149 unlawful assembly ka rioting sa to chal jayega aur common object mein hum log we will make them liable, my friends. No, you can't do that. So what happens is that the court usually at that particular time, instead of making them liable at 149, they will actually make it under 34. The constitutionality of this has been questioned in various judgments, telling that when you are charge sheeted under 149, can you make them liable under 34? Section 34 should not be used. That is what they say. Because in order to, if you're targeted, why there is a difference between section 34 and 149? I'll tell you, my dear friends, section 149 is a substantive offense by itself, because there you are a member of an unlawful assembly or you're a member of a rioting, and in that common object of committing an unlawful assembly, or it is substantive offense. You being a member of an unlawful assembly by itself is an offense. But when it comes to 34, my dear children, that is not a substantive law. It's not a substantive offense. It was only supporting sections to tell that if two or more people or persons have come together to commit a wrong or an illegal act in furtherance of common intention, that is when that is being added later on. And that is why it said that that should be done in furtherance of common intention, my dear friends. So if you look at these two things, you know that what is a substantive offense and what is just an explanatory note, that is explanation which is given in general explanation under section 34 to 38 to tell that how can you make somebody liable for omission or act as such. So if you look at all these things, you can understand when you can make them liable under 34. So when many cases, in many judgment, you have seen that 149 being given as a judgment under 34. Many have challenged it also, but the court has got convinced. The court could convince people, including people like us who read academics and kabhi kabhi jaan lete judgment ko. Kabhi hum log soch sakte hain, we can understand that this is fair enough, because if you cannot prove that it was an unlawful act, to ho gaya hai, that is satisfactorily proved by the prosecution. Only thing is common object could not be proved because there are no 5 or more people to tell that there was an unlawful assembly or a rioting. So what they do is they bring it under 34, telling that there is an act which is committed, that is prohibited act, which is under the statute, and there was 2 or more people who have committed it. Though there is no common object, you can do, and this is how you can read it in what we call as Mehboob Shah and Pandurang's cases. There is wonderful discussion happening about how 5 people are being included later on when it comes to 1 people. And in Pandurang's judgment, they acquitted Pandurang at the last stage only because his act of taking an axe and hitting it on the head, it only went to ½ inch of that. But I think that would have been enough. If you're carrying the axe itself, it's it's a deadly weapon you can make. But still, when you look at the medical evidences, there was enough evidence to show that Pandurang's act independently would not, because all the others have gathered, but Pandurang was independent one who went and acted at the last moment, hitting with an axe, and he acts and he told that Mera act itna dangerous nahi tha, so I could be made liable. Somehow they acquitted it. Only reason was there was support of medical evidence and it could not be fulfilled. So he was told that he did have a same or a similar intention, but he did not act in furtherance of common intention, so we could acquit him. So based on this, they have allowed death penalty, but others for this fellow, that means that is appellate accused, they have acquitted him as such. Oh, my dear friends, you go on and on and on. Sir, Dinesh sir? Dinesh sir?
Yes, madam.
Sir, can I take some more minutes if you don't mind?
Yeah, no problem, no problem.
No objections?
No objection.
No objections. Okay. I hope there are audiences listening.
Yes.
Yes. Thank you so much, sir. Thank you so much. So you can find wonderful judgments. You name, I have put some 25 judgments on just 34 and 34. I'll not teach case by case, but I have touched upon all the landmark judgments. Let me tell you what exactly the court would look at for the joint liability under section 34 up to 38. A criminal act which is jointly committed by several persons. Kindly understand, there must be 1 or more persons. That means 1 person you can't bring in the 34. You are very, very clear. There must be 2 or more persons. A common intention animating all of them in furtherance of which the common act. So in furtherance of means all of us will think this. इसके लिए बड़ा planning होना चाहिए, premeditated होना चाहिए. Spontaneous premeditation can also be brought under 34, my dear friends. This is joint liability. मैं बोलूंगी ना, अगर एक मार रहे तो सब मारो बोल के, बहुत सारे केसेस है उसमें मारो बोल के बोलेंगे. So that मारो people altogether can be held liable when they know that they did not premeditate the commission of the crime. They did not sit and plan as a bomb blast जैसा plan नहीं किया. Instantly, spontaneously they have come together to commit a crime as such. The concern we are talking about, the concert which we are talking, friends, about is just prior to the commission. It is not premeditated. I mean, उस जमाने में मुझे प्लान करके रखना चाहिए, ऐसा कुछ नहीं चाहिए. Instead of doing it just prior to the commission of the crime, if you have spontaneously come to a conclusion that this harm can be caused, that is more than enough. And that you can see in Mehboob, that is, what is this? वो शाह का केस जो मैंने बताया अभी अभी, क्या कौन सा महबूब शाह वर्सेस स्टेट में देखिए, instantly when they're taking away the reed and one of them comes with a gun, the other one shoots and runs away, the other one is with a bamboo stick. It is instantly formed to protect somebody as such, but the court still held that, and they be held liable because only one was actually the convicted. The court held that in case if there is satisfactory evidence against these people, they know that others have been there, but one of them have escaped, one of them stands abated. With all these things, you can still make them liable. So this is how the court interprets. Prior concert means there may not be a big conspiracy which is hashed in dark. It can have an overact, it can have an omission, it can have anything as such. So when you can be held liable, my dear friends, for an omission, kindly remember, for omission, you can be liable only when there is a duty imposed upon you. For people like me who is going to be spectator when somebody is beating, then obviously I can't be held liable as a passive spectator, whereas you owe a duty to stop it. If it's a police officer, I told you, if that police officer who is standing after the robbery and then watching it, jao, baad mein mujhe 10% de do, that is going to be an equal joint liability for a police officer, which has to be made liable as such. My dear friends, go on and on. Mere presence, it is enough. Is it a bystander can be liable? You on and on. If you keep going, there is so many principles which can be taken, and common and same intention is what which we are talking about. Now I told you, don't ever read section 34 independently. It's a humble request to all of you who are listening to me. Kindly read. All of us are thorough with 34, but we don't know after 34 क्या है. Lekin I'll tell you, my dear friends, 35 to 38 जब तक तुम लोग पढ़ोगे, you will not understand how the law talks about. So what is the reason behind the criminal knowledge? What is the effect caused by the party? If you are acting partly overact and partly omission, can you be liable? What is the meaning of operation of doing several acts in together? What I'll do is that I will tell you, is it joint liability you see? I will be poisoning you for more than 2 years. And the person who is taking care of you is also part of this. And the person who comes as a visitor also keeps giving you, knowing that there's a poison in that. There are 5 to 6 people who have been slowly poisoning you for more than 1.5 years to kill you. All the 5 people have done. And in one of them, it was a son who had a duty to protect. He is also part of that. It is omission to take care. Maybe other criminals must have been outside, but if part of that is paid, whenever you owe a duty and you have to do it, even the cooperation of doing several acts together can constitute a joint liability is what has been exactly talked about in section 737, and section 38 talks about persons concerned in criminal act may be guilty of different offenses. The reason I told you is that the prosecution, if it is unable to prove the court satisfactory in the court of law satisfactory that there was jointly liable for all the acts done together, don't ever think that the accessory or the aider will tell that हाँ उसको वो निकल गया हम भी निकल जाएंगे. नहीं निकलेंगे. You can be held liable. For example, if the person is one is beating with bamboo, the others are all having sharp weapon. If the person still survives, there can be attempt to murder for all others. But for me, certainly I can be held liable for, I think, causing grievous hurt or hurt, whatever it can be, on the basis of the facts before the court of law. So when you're acting jointly, you need not always be held liable for the same offense. If the prosecution fails to prove the case, there can be different punishments for different offenses. And that offense, though there was a single act, there can be various offenses like confinement, you can be held liable for assault, you can be liable for hurt, you can be held liable for grievous hurt. So depends upon the mental element which we are going to talk about. The recent case, that is the oldest case which we are talking about, is Karnail Singh and other versus State of Punjab, where the court has wonderfully distinguished between what is, but they did not distinguish. They told that in case if charging under 149 has been done, but the conviction has happened under section 34, if there is no injustice done to the parties, kindly understand when the court will, if they have used 34 and if instead of charge sheet 149 pe hua hai, lekin conviction 34 mein hua hai, if they're very clear that there is no injustice caused, because in Lakshman Singh versus State, it is very clearly laid down. When there is no injustice, then you can convict somebody under section 34. Karnail Singh also does that. A wonderful judgment to read, my dear friends. You can read, and then there was a doubt that can you charge. That doubt has been cleared in n number of cases, and they have taken. The recent judgment which I was talking about is Rohtas and another was the state of Haryana, which also talks about section 307, 148 interpretation. And when do you think that there was, even if there was an interested witness in this particular case, the court has come to a conclusion that if the interested witness was the only one in fields, in the farmer in the fields, who you'll find 10 people to come and see what is happening. It's not possible. So at that particular time, if you see, there was one brother who was exactly watched, who were all there. The court says that because against two of them there was clear evidences, the other ones they did not have evidences exactly to identify the people as such. So the court held that you can make them liable at least for all the provisions which have been there. There was enough evidence to show that there were 5 or more people, but for conviction they were all not there. So the court held that you can make them liable for unlawful assembly under section 130, not read with section 149. All 7 accused pleaded not guilty and claimed trial. So during that, I'll tell you, there's a wonderful discussion, and referring to landmark judgments, they have decided the recent case. And these are the few things which are minimal number, what is an alternative charge you can claim, and etc. This is what has been done, my dear friends. And then I'll just go glance once another landmark judgment of William Stanley versus State. Now, I've talked about abatement, my dear friends. Kindly understand, abatement, encouragement, counseling, procuring are all independent offenses. If you cannot be jointly held liable, if you are not, that means if the prosecution fails in creating a joint liability, I'll tell you, you can be held liable as a principal offender of second degree, as an aider or an abettor, or abatement before the fact. And if you are harboring them, you can be held liable for abatement after the fact. So you can be liable for abatement by encouragement, abatement by instigation. Abatement can happen through illegal omissions, conspiracy, and all. 110 cases. V.C. Shukla, CBI versus V.C. Shukla, Jayalalita's case. Call the name and all cases would come before you. And last but not least, when I'm talking about conspiracy, it is where 2 or more people coming together. So you have to understand the distinction of abatement by conspiracy, because conspiracy, section 120A and B were not there in the Indian Penal Code unless and until there was a Sipai Mutiny. After that only we amended that and inserted section 120A and 720B of the Indian Penal Code children. So what happens is that the courts have used this 107 and also the other provisions of abatement and made you held liable as such. So I would like to tell, when you are talking about conspiracy, you have to convincingly prove it is not in furtherance of common intention. You have to prove a prior meeting of minds, that is consensus ad idem. That itself, a conspiracy by itself is an independent offense where you can bring a joint liability. So you can see Parliament attack, you can see Red Fort, you can be Mumbai attack, you can see Subramaniam versus A. Raja. You can hundreds of cases where you can find that Rajiv Gandhi assassination, Indira Gandhi assassination, conspiracies by companies, my dear children. Volkswagen ko dekho, itna acha company hai. Johnson's and Johnson's ko dekho, itna acha company hai. All of them have done illegal activities where we can tell that they have conspired and they have acted to cause harm to others, and all other statements which can be tell how bank frauds are happening, economic offenses are happening. Arshad Mehta ka case dekho, Shantilal Mehta ka case ho, whatever you talk about, our Malya ka dekho, everybody, there is fraud in economic frauds, and there they act upon conspiracies. So based on it, I would like to tell you that there is joint liability is an extensive topic which can take, it is meant to 10 to 12 classes can be taken only to make us understand where each one of the liabilities can be imposed. There are hundreds of landmark judgments in English law as well as application of it. I don't think we are referring much. We are referring in, basically when we refer Indian cases, we are nowadays referring R versus Brainbridge, R versus Bryan, R versus Lytham, if you take, and Cohen versus Leak. In Indian judgment, you can see all these judgments. The reason I'm telling you is why these judgments have to be read is that how do you plead before the court of law? As a law student, what would you exactly understand by joint liability? That's the purpose. I'm thankful. If any questions are there, I would like to take it now as such. I've stopped sharing and I'll go for the this one, chat boxes. Any questions?
Thank you, ma'am. I now request Professor Dinesh Kolte, sir, coordinator of the webinar series, to relay the questions to ma'am if they are in. Over to you, sir.
I hope there are no questions.
Oh, either I made them understand or they did not understand. Either two of the things only, sir.
No, they have understood each and everything about madam. The way you taught us, fantastic.
Oh, somebody has asked one question, I feel.
Yes,
sir.
yes.
If you remember, there is some place, Samuel Rakshit, I think he has asked. We all know that children below age of 7 years are not liable for any offense, but suppose a child whose age is 11 or 11 months and at the time, if somebody forced him for mixing a poison with food and he has already done so, so that it can case whether it is under joint liability or single liability or abater or not. So sweet of this question, my dear child. I'll take the time to answer this question. See, when we are talking about liability of an infancy, it is read with section 82 or 83. 82 is doli in as complete innocence, so we are not going to make. But I'll tell you, even if it is child, what is a child? The purpose of telling that after 7 till 12, I know that 11 months was technically which you have asked for, but if it is after 7 years and up to 12 years, my dear friend, when the court talks about it, they will understand that did the child have a mischievous discretion? That means did the child intend to commit the crime? If it is based on that, we can make the child liable, but we will not try the child with that what we talk about. We will not try him under the normal Indian penal code. The offense may be that he has acted jointly or he stands with for the joint liability. But the only thing I would like to tell is we will take him under the juvenile justice law and take enough care of him. That is what we can do as a special mention for this, my dear friends. It's not exactly going to be, it can be a joint liability. There is no doubt about it if he has crossed 7 years and up to 12 years. But only thing is we will not try him under this, but still he can be male. It's not going to be anywhere single liability. It is going to be a joint liability. Or we can say that the child has aided him. So the offense would come only for aiding the person in commission of the crime. I hope that one question has been answered. Is there any other question? I think.
Kindly explain there is a question from the advocate Anu Sharma. Kindly explain broad and proof in regarding section 34 or 149.
What is it? Where is it, sir? Where is the question?
To explain broaden of proof in regarding section 34 or 149 from Anu Sharma.
Okay, thank you, sir. If you're talking about the burden of proof, the classification of burden of proof would be based on two. What is that classification? Usually is done from section 101 to 134. That is 101 to 100, if I'm right, 117. If the burden of proof is to be taken. Burden of proof in any criminal law is always on the prosecution. There is no doubt unless and until there is a reverse burden case, like in the Negotiable Instruments Act, in the NDPS Act, in certain offenses where we are very clear, in Arms Act, when you are holding an arm which is an illegal one, by holding an arm which is illegal possession by itself shows that there is a presumption drawn against you. Unless and until all these ingredients are fulfilled, the burden is always on the prosecution. But what is the burden which you want to distinguish? If you want to bring it, friends, under section 149, you have to very clearly prove the ingredients of unlawful assembly. And in that, maybe your liability of all the 5 cannot be fixed, but you are knowing that there was 5 or more people who have acted upon, and then based on that, you are going to make a conviction possible. And so the burden is on the prosecution to bring all the ingredients of section 141 or 146 and read with 149 as such. But when it comes to 34, the burden doesn't change. The burden of proof will be higher on the standards beyond reasonable doubt only. But only thing is, in case if you think that there is only one man remaining in section 34, or if there are only 2 people, then there are 5 people who must have committed. The medical evidence shows that it is 5 or more people who have committed, or even take 4 people. I'll not take 5 because if I take 5, it will go again to 149. But even if it is going to be on each one of them, the burden on the prosecution is to prove that each one of them have acted in furtherance of common intention. It's not on common object. So 145 talks about the ingredients read with 141 and 146. Whereas when it comes to 34, any offense, you just have to tell that his action was in furtherance to the commission of the crime. This is what, but the burden of proof is always on what I tell you is on the prosecution. It won't change unless it is. See, there are classification of burden of proof is legal burden and evidentiary burden. Legal burden never shifts, friends. It will never shift. That is what we call as burden of proof, or legal burden will never shift. But when it comes to evidentiary value or evidentiary burden, it is onus of proof. Once you have that there is a presumption, reverse presumption which is drawn, or reverse burden is drawn, then it automatically comes back to the prosecution to say that he did intend. Only in those cases, then you would talk that he did intend to commit crime. The prosecution will have little more weightage compared to what it was there in the law. The presumption is drawn against. I hope I could answer your question reasonably, counsel, whoever was at counsel. I could not get to know the name.
There is one question from the advocate A.G. Patil. My question
Yes.
is that section 114 of IPC, third or other offense means.
Where is it, sir? Come again, please.
Yes, my question, sir's question is that section 114 of IPC, third or
One-
other offense means. I hope clause 3 and 4 of section 114 of IPC, section 114 of IPC.
I can't hear the section name, section number. Can anybody type it for me?
Section 141 of
141.
Yes,
141. Unlawful assembly ingredients.
Yes, and clause 3 and clause 4.
You want me to specifically answer that question
No.
of 141 and 142, 141 clauses?
Clause 3 and clause 4.
Oh my God, I did not keep my bear, but I'll still try. I'm just so sorry for that. I'll just give me a minute. I'll do that. Just give me a minute. I'll do that.
I hope that may be any other offense.
No.
To commit any mischief or any other act.
Yeah. I'll just look at it, sir. Let
And
me
any
answer
other
specifically.
offense.
Any other offense. I am so sorry, extremely sorry. I did not expect this question. I'm so happy for that. But I'll just tell you what is exactly happening here. Where is that? I should have kept a Bayrak for myself, but I thought I have done homework. So this is what happens when you do too much of homework also. Any other offense? Kahan aayega mera punishments? I'm so sorry for that. Can you just give me a one single second?
Clause 3, madam, clause 3.
बोल दीजिए sir, आप clause 3 बोल दीजिए, मैं बता दूंगी क्या है.
1 minute, I will see in my.
You just read it out for me. Or just give me a second.
Section 141.
I'm so sorry. I kept my books on the other room also, so I had to run back. Yes, now I have it with me. Yes, sir. Thank you so much for the question. I'll do some homework now. Yes. 141 ka clause 3, sir. Thirdly, to commit any mischief or criminal trespass or other offense. Okay. So he wanted the interpretation of other offense. Whenever a statute has given a couple of offenses specifically, my dear friends, that means it has said that kind of mischief and criminal trespass. It says that this is only hinting at few offenses, but it doesn't say that I'm stopping at that. That means the list of offenses which I mean in thirdly doesn't stop at mischief or criminal trespass. Any other offense includes, the list is not exhaustive, and any offense committed which is to be read with this or even within the penal laws, you can be held liable for unlawful assembly. This is the interpretation which is given for thirdly. Sir, got it?
Yes.
Yes, sir. Any more questions? Yes, thank you. Atmaram Jagannath sir. Yeah, it's just a generous rule. Thank you so much. Thank you, Atmaram sir.
So, sir, if there are no further questions, can we proceed with your permission?
I hope with the permissions of the madam, shall we proceed to the concluding?
Yes, sir, as you wish, as you wish. I think I've done my job now.
Okay. Thank you, ma'am. At the very outset, I'd like to thank our resource person for today, Dr. Nandini CP, ma'am, for joining us despite of her busy schedule. I'd also like to thank the participants who participated in the discussion and also asked good questions. I thank our respected principal, Dr. C.M. Rao, sir, for making this webinar series possible. Furthermore, I also thank Professor Dinesh Kulte sir, coordinator of the webinar series, for organizing such enlightening webinar session as well as the series. I also like to thank him for giving me this glorious opportunity for moderating and anchoring this program for you. With that being said, I formally conclude today's session. Thank you all and have a very nice day.
Before that, before the concluding, first being a coordinator, I express my deepest sense of gratitude to all respected resource persons who delivered us this intellectual feast on the topic of the IPC for 1 week. I express my sincere thanks to all participants, principals of law colleges, other colleges, law teachers from throughout India, and educators, even students from throughout India, not only India. Some students are from the Kenya, some from the Saudi Arabia, so they are attending this law lecture series. Then even the police officers from the state of Maharashtra and other state also, all the officers from the various departments of the Maharashtra, since day one, as police officer like Bhange sir, then officer like Rajendra Kare sir, all these are attending since day one first. Even Dr. Satyanarayana Kankara sir from the Vishakhapatnam, Dr. Bodhu Nasimasan from Vishakhapatnam, they are attending this lecture series since last 1 week. Therefore, I express my thanks to them. I express a special thanks to all the anchors, especially me and Shubham Jaiswal, who assisted us for this technical department. I express my thanks to our beloved principal, Dr. C.M. Rao sir, who always encourage, motivate us to organize such a program, as well as vice principal and coordinator of the IQAC. Thanks to all them who assisted us to make this program success. Once again, I thanks all. Thank you. Even Advocate Jagannath Atmaram Patil Singh also attend all this program. Thank you. And we have already sent the feedbacks to all the here on the chat box, and even some officer from the income tax department, they also attended. Sri Ashok Magnani, he is there. He just sent the special message to our principal Rao sir also. Thank you, madam. Thank you all the participants.
Thank you, sir. Thank you
Wonderful
for the
session, madam.
opportunity.
We have observed. Thank you.